Our next case is Beach's Seafood Kitchen versus Department of Business Professional Regulation Division of Hotels and Restaurants.
Good morning, Your Honor. My name is Al Millar. Office is in Mayport, Florida, and I represent the appellant. To give you some type of a background, it's a very unusual case, and actually I think from our perspective anyway, I think it's kind of like driving a round peg into a square hole. This is not your typical restaurant situation. The appellee is, of course, the Division of Professional Regulation and the Division of Hotels and Restaurants, and it concerns an inspection of the appellant. Metropolitan Park in Jacksonville extends from the stadium to the river. It's a large grassy field with an amphitheater on the river. It probably maybe 10 acres or more. One big grassy field is enclosed by a fence. The appellant is engaged in a business where he does temporary events that range in different fairs, festivals, things like that. And as such, he does not ever operate on his own premises. He's always going to some place and renting a premises, and they assign him a space, and he sets up shop and brings the freezers in, brings the cooking equipment in, brings the food in, and sells it and then leaves. Now, in this situation, there were two events. One was called the Jazz Festival, which I thought was over, but they brought it up in the complaint. And that occurred in April of '06, which was followed by the World of Nations, which is what we're concerned with here today, which was started on May 4 of '06. On May 4 of '06, it was what they call the Children's Day. World of Nations was events from all the nations of the world, and all the buses bussed all the kids in from all over Duval County and Clay County and Nassau County and Baker County, I think. It was supposed to last until 2 o'clock or at the discretion of the bus driver. I think the evidence will show that at 1 o'clock the bus drivers packed them all up and took them back so they could get them back to the school by 2. But in any event, the first problem we have, and there's some technical difficulties we feel that are contrary to law, others are questions of substantial evidence on the record as a whole. Now, we recognize this court's holding and others that you must adopt the findings of fact if they are supported by substantial evidence on the record as a whole. We understand that. That's not a problem. And we hope to have you believe that there was no evidence to support some of these findings of fact and some of the very crucial ones. But starting off with the technical part first, the administrative complaint was first brought against Jack's, J-A-X Seafood. Jack's Beach's Seafood was the name of the respondent in the administrative complaint. Jack's Beach's Seafood is unquestionably a fictitious name. It is not a corporation, it's not an individual, it's not an association, it's not a legal entity. And as such, we submit under that Florida medical decision cited on page 3 of my brief, it cannot be sued. Only legal entities can sue and be sued in the state of Florida. Now, it may be technical. I'll just raise it for your consideration. Certainly, Beach's, the real license holder in this case is called Beach's Seafood Kitchens, Inc. is the name of the license holder, DBA Jack's Beach Seafood. They were served. We have no question about that. But originally, the respondent was named Jack's Beach Seafood. I noticed this. I filed a motion to dismiss, and it was heard by Judge, I think it's Judge Whitford. And she denied it. It was telephonic. It was not transcribed, to my knowledge. And she basically said that's a defense. So I issued it, put it in the defense, and then amended answer. They then changed the name. I think the judge did it first in one of her rulings to Jacksonville Seafood, Jacksonville Beach Seafood, which is the same as Jack's Beach, except they spelled the name out entirely. To my knowledge, I don't know if there is a corporation named Jacksonville Beach Seafood. I have no idea. But it's certainly not connected with the appellant in this case. But so much for that.
Now, your clients did receive notice.
Sir?
Your clients did receive notice of the proceeding and
the real name of the corporation is, as I mentioned, the first time that real name has been used is in this court. This is the first time. Now, I don't know if you can change the name at this point in time in the proceeding. My experience has been that the Court of Appeals can do about anything they want to, so I imagine you can't. I just don't know. Second point is the 3-day and 4-day event. Now, they have a different. In a 3-day event, a license holder may use his license to qualify for a 3-day event. Nothing else is required. As long as he's licensed to good standing, he may operate in a 3-day event. This was a 4-day event. There's still no question in the record at all that in 4-day events, his license is no good. You must have a special license for a 4-day event. And that's what's the case in this scenario. Now, no license is also uncontroverted, that no license was ever issued in this event, for this 4-day event. Now, when you get down to yet in the final order that's under appeal, they placed a penalty on the license holder's license, even though he was never licensed for that event, and there was no license issued. We think that's wrong, and it doesn't fit. If a license should have been issued, well, really they should have inspected first, which we think they did anyway, but they say they did not. And then if there's violations, they should attack the license if they issued that day. But what we're getting down to, when you get down to some other points, they found 2 violations primarily. One violation, and the primary thing in the whole thing is the question of roaches. Now, certainly roaches are a very despicable type of thing when you talk about food service. Now, it's their contention. The evidence we think is it's primarily uncontradicted that it was sitting next to a dumpster. There's a picture of it in evidence. I think it's 11D or 11E. I'm not sure which one. But it also shows it leaking at the bottom. All the appellant's witnesses testified that it was sitting there. They all testified there were no roaches when they got there in the morning, and that makes common sense. Who in the right mind would bring a whole lot of roaches to a food service thing? It doesn't make any sense. Further, the evidence is uncontradicted that all the roaches that were discovered after they closed were live roaches, and if there were roaches brought there in the morning in a freezer, they were dead roaches because they've been frozen by then. But so much for that. The rule as cited in the appellant's brief is correct, that the rule in question is the presence of insects, rodents, and other pests shall be controlled to minimize their premises by, 1A, routinely inspecting incoming shipment of food. All the food was in plastic bags that was inspected. Routinely inspecting the premises for evidence of pests. The evidence is uncontroverted by the pest control man that he inspected all the equipment twice monthly and also fumigated all the equipment every time it was used before and after an event. Using a method of pests are found, such as trapping devices or other means, as specified under 702.12, 706, and 713. Well, that has to do with trapping it. Of course, you can't trap a roach too easily, not in this situation. And finally, eliminating the harboring conditions. Well, this is the city of Jacksonville's property, not his property, and he has no control over fumigating the entire metropolitan park. So using this standard doesn't fit in this situation at all. It fits in a regular restaurant situation where they can control the harboring, they can control the spraying, they control everything, and if roaches are found in that situation, then certainly it should be held liable for it. But to hold my client liable for something that is the fault of the park is unconscionable.
Mr. Millar, other than your argument about whether or not this is the right party, though, isn't this really just a question of whether or not there was competent, substantial evidence to support the decision? And I understand there were witnesses who indicated that there was no dumpster close by, but weren't there other witnesses who testified that there was no dumpster? Whereas your witnesses testified there was, the other side testified there was no dumpster.
Well, there's no. To my understanding, I remember there was some testimony about. Both the inspector witnesses testified that they saw the roaches, they were alive. There's no question about that. They also testified that when asked the specific questions, I can give you the citation and point if you want, but they said, I asked them, did you see any roaches on the food? They said, no. I said, well, were they closed or were they open? And they, instead of answering those questions, they said, well, one of them says, we think an operation was going, as I recall. The other witnesses said, well, people were milling around and food was present. Well, obviously, people would be milling around with all the commotion that was going on at that particular station at that particular time. But no one ever saw anyone eating food, and all the witnesses for the appellant testified that they had closed. And obviously, once the roaches were discovered, which was a shock to everyone, they were all hustling around trying to take care of that problem. They certainly weren't serving food.
But wasn't there a witness who testified that Miss Darlington, who's associated with your client, indicated that the roaches came from her trailer?
She denied
I know she denied it. I know she denied it, but wasn't there a witness who indicated she said that?
Mr. Peeland said she said that, yes, sir.
And didn't they spray the food with bug spray?
Excuse me?
And aren't there witnesses that said that food was actually, that they saw the food being sprayed with bug spray to kill the roaches? Is that in the record?
There were no roaches seen on the food at all by any witness.
But a witness testified that they were spraying the food with bug spray.
The witness testified that she sprayed insecticide on the bags, and she said she was trying to hit them, but obviously they're on the bags. I'm sure they got in the bags anyway. But they threw those away. I mean, there was no question. They didn't use those. And this was after they had closed. They had closed at 1 o'clock. And they did everything that they were supposed to do, and yet all these people showed up, and they cited them for all these things. The other question is the point of discriminatory inspections. Typically, an inspection take place when food is being served. If food is not being served, there should be no inspection. In Jazz Festival, it's uncontradicted. They inspect them before the premise is open. And in the World of Nations, they said they'd inspect them after they closed. Now, no food was being served. They would have time to correct it if there was a problem. They were doing the best they could. I asked both the chief inspector and Mr. Bombadigan, the director, what would they do if in a similar situation? Mr. Bombadigan said, well, it shouldn't have been as severe as that. Well, that doesn't answer the question. I asked Mr. Phelan the same thing. What would you do? He said, well, I wouldn't have sprayed the bags. Well, what are you supposed to do? You can't trap them at that point in time. They're there. You should get rid of them. You should kill them. You should dispose of them. And I think they did everything they could to control the situation. You have to understand this is a shocking thing to open the freezer and see all these roaches at a food festival. It's certainly most derogatory, most appalling to them. They never had that before. And Mr. Baker, the fumigation man, said he never ever had any problem with them. He's been spraying their equipment for 5 years or better. They never had a problem. Ms. Darling testified that they never had a problem in 12 years. So all of a sudden, if it happens here, it happens where the dumpster is nearby, and it's obvious they were live, so if they weren't imported in frozen, they would be dead. It had to have been there. Their position is, and they said, well, it doesn't make any difference where they came from. Well, I think it definitely makes a difference where they came from. If you're trying to penalize my client for something that's not his fault, it most certainly makes a difference where the roaches came from.
Mr. Millar, you're into your rebuttal time if you want to reserve that.
Thank you.
Yes, sir.
May it please the Court, Counsel. My name is Jennifer Cheddar, and I'm here today on behalf of the Department of Business and Professional Regulation Division of Hotels and Restaurants. The Department urges this Court today to affirm the final order issued by the Division because it's based upon competent, substantial evidence in the record as found by the Administrative Law Judge at the formal hearing below. I'll deal with each of appellant's arguments in turn. Let me first say that I think this case has been well briefed. The Division's positions on many of the arguments presented here today have been put in brief, and we'd urge the Court to rely on our brief toward that end, but I will address some of appellant's specific arguments today, starting with his technical issues. The technical issues raised by the appellant I heard as twofold. First of all, that the wrong entity was served. Judge Allen, as you alluded to, the standard of review for that notion would be found in Section 12068 Florida statutes, which requires that there be a material error in procedure. This was decided by both Administrative Law Judge Davis and also then reviewed again by Administrative Law Judge Hood at the hearing below when raised by the appellants. And what they indicated was that the administrative complaint charged the proper food service license. So everybody knew which license we were talking about. The other thing is that the appellant obviously received notice of the charges against it, appeared with counsel at a formal hearing. To the extent there's just been no material error in procedure here. The appellant has been afforded every opportunity to argue this case and the merits of it. And for that reason, we would urge the court to reject any argument that it's some type of technical violation requires a reversal of the final order. The other notion advanced by appellant is that the wrong license was somehow disciplined because there is no temporary license in this case. As noted by a footnote in our answer in the division's answer brief, the appellant has a permanent food service license. That's the license against which action was taken. It's that permanent food service license that entitles them to apply for temporary licenses to appear at these festivals and things like that. The way that it works at these festivals is in the morning, the division representatives go around to all the booths, hand out pieces of paper that are applications for temporary licensure to appear at whether it be a jazz festival or this World Nations Festival. Then later in the day, after giving the applicants an opportunity to fill out their paperwork, the division comes back by and does the inspection and issues the temporary license. When the division came back by in this case, they found about 50 roaches in the freezer and the license holder spraying bags of food with insecticide. They did not issue the temporary license. So that's why the action wasn't taken against the temporary license, is because it was never issued. But it isn't inappropriate to take action against the permanent license in this case, and that issue was decided below as well. The other arguments advanced today by appellant are factual disputes. And as the court has pointed out, both Judge Davis and Judge Allen noted that there was a hearing in this case. Everyone got to present their evidence, their opinions. The inspectors testified, and the findings of fact made by Administrative Law Judge Hood below are supported by competent substantial evidence, as noted in our brief. The two factual issues that I heard today were decided by Judge Hood conclusively, and those findings should be affirmed because they're supported by evidence. The first one is appellant's suggestion that its establishment was closed. Specifically, on page 235 of the record, Judge Hood's 17th finding of fact is that respondent's food service operation was still in operation when the inspectors arrived. In the answer brief, I detailed the testimony of both of the division's inspectors that noted that there was food for sale at the appellant's premises, and that there were people milling about. So just because they were spraying insecticide and things were starting to wind down doesn't mean they weren't in operation. That finding of fact should be affirmed on appeal. The other argument advanced today is that appellants somehow shouldn't be held liable unless they specifically brought in a jar of roaches and put them in their own freezer. Again, these notions were rejected by Administrative Law Judge Hood below. She specifically found that the greater weight of the evidence, that appears on page 238 of the record, the greater weight of the evidence indicates there was no dumpster or trash compactor at that location. So, Judge Allen, as you noted, there's conflicting testimony, but that testimony's been resolved against appellant at a formal hearing below, and those findings were affirmed by the division. It's clear from the precedent of this court and general notions of the Administrative Procedure Act that when folks are afforded a formal hearing and factual issues are determined at that hearing and then affirmed by the division on appeal, those should also be upheld, or in a final order, those should also be upheld on appeal. Unless there's any questions, we rest on our brief and urge that we affirm the division's final order. Thanks.
Thank you, Mr. Scott. Mr. Millar, you have a little bit of time remaining.
Yes, sir, very brief. Number one, as a matter of law, we submit that the rules specifically says that there can be used a license if you have a 3-day event or less, but 4-day or more, you must get a special license. There's no question no special license was issued. And we submit that to go back on, technically, they were not really licensed there to do the business that day. And so if they're not licensed to do business, I don't know how you can go back on their license. That's the first point. Second, the rule in question about roaches specifically says that minimize their presence. It's uncontradicted. They did everything in the world to minimize their presence and to take measures to control it once it was discovered. I don't see how that can possibly be a violation. I asked both parties, both Von Bodegen and Phelan, what they would do, and they had nothing to suggest other than what we've already talked about. Finally, as far as all three clients say that Mr. D'Antonio, one of the inspectors, came by in the morning and inspected and was supposed to get a check later on that day. She testified she wasn't there that morning. I noticed the counsel says that the representative came by and said she'd be back. She said she wasn't there, that they were closed, and that's all I have. Thank you.
Okay, thank you both.